Welcome to the podcast. My name is David Jolly, and today we're going to deep dive into a case that changed the sound of American policing forever. Miranda versus Arizona. Now, you've probably heard the words before for Miranda on TV or in movies. You know, you have the right to remain silent. Anything you say can and will be used against you. Yep, that's Miranda. But did you know, or do you know who Miranda was, or why the Supreme Court decided that the cops needed a script? Well, pull up a chair and a coffee, because that's what this podcast is all about. All right, let's rewind to 1963 in Phoenix, Arizona. Ernesto Miranda was a 23-year-old man with an 8th grade education and a guy who'd had a few run-ins with the law. So he gets picked up by police in connection with the kidnapping and rape of a 18-year-old woman. The cops interrogated Miranda for 2 hours. No lawyer, no, you don't have to talk, no, you can wait for an attorney. And guess what? He confessed. Well, they wrote it down. He signed it, and the prosecution presented that confession in court. Well, surprise, surprise, Miranda was convicted. But here's the twist. He did not know that he maybe had a right to stay quiet or that he could request a lawyer. And the Constitution, as it turns out, well, it cares about things like that. But this case wasn't just about Miranda. It was about how police question suspects and whether that process respects the Fifth Amendment right against self-incrimination and the Sixth Amendment right to counsel. Now, let's be honest for a minute, and that is, confessions are powerful tools. They often seal the deal for prosecutors. But the Supreme Court said, hold on a second, just because someone talks does not mean the confession was voluntary, especially if they did not know that they could, in fact, stay silent. So in 1966, the Supreme Court delivered a 5-4 decision. The majority said, from now on, suspects must be told their rights before being interrogated in custody. It's not optional, not implied. It's mandatory. And just like that, the Miranda warning was born. Not because the court liked catchy phrases, but because it believed real rights require real reminders. So here's the basic Miranda warning, just in case you missed your favorite crime show this week. You have a right to remain silent. Anything you say can and will be used against you in court. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. All right, here's where it gets really, legally interesting. Miranda only applies when you're in custody and being interrogated. So, no, an officer just chatting with you on the sidewalk does not have to read you your rights. But if they arrest you or bring you to a station and start asking you about that stolen lawn gnome, well, yes, it's Miranda time. Now, remember Ernesto Miranda? Well, he got a new trial, this time without the confession. And he was still found guilty. And as a result, he went to prison. Later, actually not that much later, Miranda himself was killed in a bar fight. And the suspected killer? Well, here's some irony. The suspected killer was arrested and advised of his Miranda rights. So where are we now? Well, Miranda is still the law, but over the decades, and true to form, courts have chipped away at its edges. For example, if you start talking without being prompted, well, that's not protected. If you waive your rights voluntarily, even without fully understanding them, well, your words can be used against you. But even with those caveats and changes, Miranda remains a pillar of American criminal justice. It's not just a formality, it's a check on power. A reminder that the government can't steamroll your rights just because you're in a tough spot. They can try, and they will, But Miranda gives protection that didn't exist before Ernesto Miranda challenged the legal authority.